You're listening to an IACP podcast, www.iacprx.org. Hello, everyone, and welcome to the IACP podcast. This is Scot Maitland, your Director of Communications and Publications, and your host for the IACP podcast. Thank you for joining us. This week, I caught up with David Miller, our Executive Vice President and CEO, to talk about office use. So, Dave, let's just jump in and start the show. The biggest question I hear from compounders is office use legal? So, is it?
Well, that's a great question, because I think before we can even answer that, you got to ask the question, what is office use? And that may sound like a pretty basic and just something that we all understand as compounders, but in reality, there's a lot of different interpretations as to what constitutes office use. I think let's step back a little bit, forget being compounders for a second. One of the things that a lot of folks forget about is that for the longest time, pharmacies were one of the main distribution points of prescription drug medications for physicians in the United States. Some doctors used to be able to buy directly from drug companies, but if they needed something for their office to take care of a patient, you call up the local pharmacy and you just buy it from them. And we still have that model today, by the way. And that's, again, not just compounding, but let's say a doctor needs a couple of bottles of flu vaccine. He can't get it from his regular supply house. You call up the local pharmacy and purchase it from them. So office use, from the biggest and global perspective, is the ability of an authorized prescriber to purchase medications from pharmacists to take care of the patients in their practice setting. So then that's office use, that's the basics. But then let's kind of focus a little bit more on compounding, and that's where things become a bit more complicated. First of all, obviously compounds are not FDA approved. They don't necessarily have an NDC number. So the order that comes from a physician, that phone call saying, hey, doc, I need to get X number of vials of such and such medication, they're really giving us an order that is very similar to a prescription. It is I need something, this formula, this quantity, this amount, I need you to make it up for me. And that's one of the areas where we seem to have a lot of overlap between, is office use medications that are compounded a prescription, or are they an order? And in some cases, they're a little bit of both. So if we know that a compounded medication for office use is being requested by a prescriber, our biggest challenge comes in answering the is it legal question is, what does my state say about the ability of a prescriber to purchase medications from me as a pharmacy? Then we have to look at, are there any limitations? What's the form of that look like? Or is there a variation between controlled and non-controlled substances? Is there an amount that I am limited to? So let's dig into that a little bit more. Number one, you cannot do an office use compounded order for a controlled substance in the United States. And the reason for that is because the DEA requires a very specific type of order to be placed whenever you want to obtain a medication that contains a controlled substance. For a C2, we know we have to use a Form 222. We also know for a Schedule 3 through 5, that has to be on a formal medical order or invoice. And unfortunately, the DEA says that you can't do office use compounding if there's a controlled substance involved. So that's controlled versus non-controlled. Let's go to the next aspect. Yes, there are limits in many states on the amount of medication that any pharmacy can sell to an authorized prescriber, not just compounds, but manufactured products as well, because the states also have limits that determine whether or not your actions are those of a pharmacy or if you are a wholesaler distributor. And we do have some states that require you to register as either a wholesaler or distributor if the amount of medication that you're selling or transferring to a physician's office or a hospital or a clinic exceeds a certain percent. Then we also have states that say, no medication, no compounded medication may leave a pharmacy unless it has a patient-specific name associated with it. For example, New York, Massachusetts, Minnesota, three right off the top of my head, where office use dispensing of a compounded medication is actually precluded by existing rules within the State Board of Pharmacy and the Pharmacy Practice Act.
Well, then, since it varies from state to state, what are some examples of the variations that compounders need to know about?
Sure. Okay. So let's dig a little bit more into the states. First and foremost, the Prescription Drug Marketing Act of 1987 set up for the very first time the authority of states to oversee wholesalers, distributors, and manufacturers. With that came a recognition that, hey, you know what? We have always had this process by which a pharmacy could sell a medication to an authorized prescriber. We want to preserve that. But what the states did was they set a limit, and that is the commonly recognized 5% limit. Pretty much if 5% of my annual sales is a sale, an actual transactional sale that's not a patient-specific prescription or a prescription order, I can sell less than 5% of my annual goods to a prescriber or a hospital or clinician, what have you. So there's a 5% rule that seems to be in place. In some states, Florida is a great example, if you do more than 5%, you have to obtain something called a retail distributor permit. That's in addition to your pharmacy permit. Other states, you have to register as a full-blown wholesaler and distributor as well. So those were put into place to help us ensure the integrity of our drug supply system, to minimize the entry of counterfeit or secondary or gray market products. And that goes back quite a ways, as I said, to 1987. But then we have to also start looking at the individual states. We have some states that specifically prohibit, as I mentioned before, office use compounding for humans. New York and for Massachusetts and Minnesota, you've got to have a patient-specific name. In the case of other states, the law is actually silent. It doesn't say that office use is permitted, and it doesn't say that office use is prohibited. So in our form of government, unless there is a law that says something is not permitted, then in that state or that locale, that action, in this case office use, is permitted. Now, we are starting to see in certain states formal acknowledgement in pharmacy practice acts through statutes or regulations that office use is permitted. Last year, Utah and Colorado both passed new state legislation allowing office use within their borders. This year, Arizona has a piece of legislation that their legislature is considering. In the state of Maryland, we had a bill passed in 2014 that specifically permitted office use purchasing and distribution by two types of physicians. It even went outside the pharmacy profession. So one of the first things, and this is going back to your original question, Scott, one of the first things that we have to ask ourselves when we're looking at, is this legal or not, is I have to turn to my Pharmacy Practice Act. I have to turn to the laws in the state in which I'm practicing. Is there something that says that I can, that I cannot? And that's really our very first place where we go to make sure that something is legal.
Okay, well now, Dave, I've heard that federal law says that office use is prohibited. Is that right? And how does that mesh with what the states say?
Well, actually, there is no federal law that addresses office use, and that applies to both controlled and non-controlled. Let me start with the DEA and controlled. The law does not prohibit office use compounding and distribution of controlled substances. That is a rule and a regulation that was developed by the DEA to help ensure the integrity of the distribution of controlled substances. I think what you're asking is, with the enactment of the Drug Quality and Security Act in 2013, what was the ruling there? What does the law say about office use? And in actuality, the law is silent on office use. So the Food and Drug Administration's position on office use is actually an interpretation of the Drug Quality and Security Act, because in DQSA, it says that the exemptions provided to a compounder, exemptions from having to adhere to CGMPs, from branding and labeling review and the filing of a new drug application, all hinge upon the words individual patient prescription or individually identified patient. That's used in the Drug Quality and Security Act. The presumption of the FDA is that because it doesn't explicitly permit office use, it therefore must be prohibited. And that, again, is in contrast to what I said earlier. Just because it's not permitted specifically doesn't necessarily mean it's prohibited. So we actually see that there's a genuine disagreement between the FDA's interpretation of the law, what the law actually says, and what Congress said when it passed the law, that it did not intend the DQSA to supersede any existing state laws that permit or regulate office use. In fact, because it didn't provide for an override provision, and Congress could have done that, the understanding was, and is included in statements of the record, is that Congress wanted the states to decide what to do with office use. Now, that's real easy to say, but the problem that we have right now is the federal agency responsible for enforcing the Drug Quality and Security Act, the Food and Drug Administration, is saying, here's how we look at the law. The states, on the other hand, who are responsible for my license and my pharmacy's permit, they're saying, well, this is how we look at the law. And unfortunately, those two positions are diametrically opposed. Who has the authority? Ultimately, it rests with the Board of Pharmacy on dictating how a pharmacist within their borders practices. That's who that pharmacist is accountable to. At the same time, we do have the threat of federal action because of the interpretation, and we believe an incorrect interpretation of DQSA when it comes to the office use question.
All right, Dave, so we're up to our final question for the show. So Dave, how do we get this fixed?
There's a couple of ways that we can have this fixed. First and foremost, change the law. Go back into the law and make it clear that office use is permitted and that office use is not prohibited. So that's number one, technical correction. The other way is for Congress to make it clear in directions to the Food and Drug Administration, separate from law, that this is what they meant, this is how they want it interpreted, and this is what they want the agency to do. As the legislature who sets the policy, they have that ability as well. So that's another option. And then the third option, obviously, is if there is a discrepancy between federal law and state law, that will have to be something that courts are going to have to decide for us. So where do we stand with that? We've got those three options. Fix the legislation, get congressional intervention, take it to court. Well, we're still relatively new to this law. It's only been in effect for a year and a couple of months. We're only just now seeing many of the guidance documents coming out of the FDA and their interpretation. We just recently had that clarification from the agency to Congress. One of the things that IACP has done is help put together a coalition of other pharmacy associations, other medical associations, organizations that have a vested interest in making sure that medication access remains what it was prior to DQSA. And that coalition, what we call our Fix DQSA Coalition, has already reached out to Congress, both on the House side and the Senate side, asking for support in that technical correction. We believe that the best thing for us from a practitioner standpoint is getting clear, clarifying language into the DQSA law itself in Section 503A that says if a state wants to permit office use, it can do so, and that nothing at the federal level prevents that state from doing that.
All right, Dave, thanks for clarifying that. Hey, IACP members, do you have a topic you'd like to suggest? Maybe you have feedback on our first show. Do you have a question? Call the IACP podcast at 713-730-9043 and leave a message. This was our first podcast, so be sure to subscribe on iTunes and share this podcast with your colleagues on Facebook, LinkedIn, and other social networks. Dave, before we close out the show, is there anything else you'd like to add?
For those of you who are worried about the Drug Quality and Security Act and its impact, not only on your business and your practice, but also your patients and your relationship with prescribers, doctors in your area, you need to be coming to Washington, D.C., June 6th through the 9th, to bring our message about the need to fix the Drug Quality and Security Act to the ears of congressmen, to the ears of senators. This has been an initiative that is driving our profession forward something that we are doing as compounders in collaboration with other pharmacy groups and with medical associations as well, because we all recognize that there's some problems in our Drug Quality and Security Act, and there's a lot of questions that could potentially jeopardize our ability to provide necessary care to our patients. So you need to be in Washington for Compounders on Capitol Hill, first week in June. Register for it. Now's the time to do it. Simplest way, go to the IACP website, click on the big banner that says Compounders on Capitol Hill. And that website address, www.iacprx.org/CCH. We'll see you there in Washington.
Hey, Dave, thanks again. And listeners, make plans to tune in next week to learn more about APIs and DQSA. To the Healthier Pharmacy, this is Scot Maitland, Director of Communications and Publications at IACP.